and moving force behind envisioning a movement which revolutionizes how companies view and implement legal compliance, and has created significant difference towards workplace safety, specifically for women. Though Complykaro, Vishal sir seeks to unify three main vehicles, namely consultancy, training and legal counseling, to work unitedly towards empowering corporates with a mean conducive for higher level of productivity, namely secure environs. In his wide range experience, Sir has found that many organizations are ignorant or unable to comply due to prohibitive cost. Add to this the logistic of coordinating with multiple agencies. This is precisely why Sir has set up Complykaro to be an end-to-end compliance solution partner to organizations which aim to, in time, be a full service support arm for any company in any sphere. Sir began his career by joining his family tourism business and then proceeded to Enam Holiday Private Limited, the family office of Enam Group, where he headed their new and emerging business initiative, Wishlist, being part of the private equity investment team. Sir is a commerce graduate from Mumbai University and a diploma holder in business finance from ICSI Hyderabad. Sir has been regularly speaking about sexual harassment of women at workplace and its implication for organization at various public events such as the one for the media, the Press Club, Mumbai, another for PR agency, Press Relations Council of India in Delhi, and at Western Indian Automobile Association, called as Relay to the Belly Drivers Briefing. Thank you, sir, for being with us. And I request Kishore sir to felicitate him with a token of thank you from CCGRT.
Good afternoon. So I'll just show you a brief video which we've created, which kind of gives you a sense of what this law is all about, and then I will take you through a short presentation, and then I'll be in a position to take question and answers from you.
Vinayak, I have worked very hard to build this company, spent many sleepless nights. I have a hard-working team of honest employees. What if one of these employees brings it all down? It almost happened to me, but I had taken care. What do you mean? What if one of them commits an offense?
I have never broken a law, nor have any of my employees.
And what about sexual harassment at the workplace? It has been found that 1 out of every 6 women experience sexual harassment at the workplace. So a new law was passed in the parliament recently. If you fail to comply, it could lead to hefty fines of up to 1 lakh rupees, cancellation of your business license, and even lead to risk of incarceration under the Indian Penal Code. You can be sure it will affect you, your family, and your business.
What should I do?
Ensure absolute compliance with the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act 2013. Call the experts.
So I'll take you through a short presentation about the law, and then you can ask me questions, and I'll be very glad to answer them. So this is actually a recent law which has been promulgated by the Government of India about 15 months back. What we believe is basically that this law requires all arms of society to come together and make a difference to women's safety. So generally, whenever such a thing, any incident happens, people tend to ask, who's responsible for women's safety? Is it the government? Is it the organization? Or is it people like us? Our belief is basically that organizations are now being made responsible by the Government of India to ensure that no women is harassed within their organization. You will also be knowing that because of the Nirbhaya case, what has happened is they have made sexual harassment as a criminal offence. So the Indian Penal Code was actually amended in February 2013, by virtue of which today if somebody is harassed, she has an option of making a criminal complaint as well as a civil complaint. So this act, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, actually gives a right to every woman to demand a safe working place, not only from employees of the organization, but also from any person which they come in contact with in any premises. So supposing if a woman is actually gone to a mall or an airport or an office, any place, and if for some reason she is harassed out there by any person, then the organization is duty bound to help her get redressal. So it could be if she wants to make a civil complaint within that organization, if the employee is actually one of the employees of the organization, then she has to be helped by the organization make that complaint. If she chooses to make a criminal complaint, even for that matter, the organization has to provide her assistance. So this is actually, I think so, one of the over-encompassing obligation on every organization, that in your premise, it's not about women employee, it's about any woman within your organization. If she is harassed, she has to be provided assistance. Again, we had done a recent survey where we find that about 97% of the organizations, and this survey was done actually in Nariman Point, that 97% of the organizations are either not aware of the law or they are not aware as to how to comply with the law. And assuming that this survey which we had done is in Nariman Point, then our belief is that basically if we were to extrapolate this on an all-India basis, I think so the awareness of this law will be not even 0.5%. So the biggest challenge as far as this law is concerned is actually the implementation of the law, or sorry, the awareness of the law. Recently you would have read 2 weeks back, even Menka Gandhi, who is the Honorable Minister for Women, Government of India, has actually admitted in Rajya Sabha that most of the government offices and 90% of the private firms have not complied with the law. And she's actually given a stern warning to the entire, I would say, business community, that you either comply with the law or you will face severe consequences. Also, one of the, I would say, more relevant to this August gathering is the fact that there are annual disclosure requirements in your annual report. So the law says that basically if you have to file an annual report, then you have to disclose in your annual report compliance about this law and whether you have received any complaints, and if you have received any complaints, whether they have been disposed of or not. In case you are an organization which does not have to, I would say, prepare an annual report. So if you are a partnership or a proprietary or some other form of organization which does not require to form an annual report, then you have to file a report with the district officer. So basically for implementation of this law, a district officer has been appointed in each district. So you have to ensure that you actually complied with this law by filing a report there. Again, so in our survey and in our interaction with various of the organizations, what has been the reason for non-compliance with the law? I believe the foremost being that people are not aware of this law. This is 15 months old law. Then people think that okay, there is no such law because they are not aware, or it is not mandatory. This law is mandatory for every organization. It is irrespective of size. So as Ashok ji had mentioned, applicability of this law is every employer without any exception. So therefore every organization, be it proprietor, partnership, LLP, trust, society, obviously companies, private limited company, every organization has to comply with this law. This is also applicable to small organizations. There are certain provisions which are not applicable to a small organization, and that is primarily for organizations which have less than 10 employees. So up to 9 employees, there are certain provisions which are not applicable. I will share with that with you shortly. Again, people think that if I don't have a women employee, then this law is not applicable to me. That's a myth. This talks about harassment of women. This doesn't talk about harassment of women employees. So basically what it talks about is that no women employee should be harassed within your organization, within your premises. And if it happens to be one of your employees, then you have to have an internal redressal mechanism in place to help the women employee make a complaint. It can also, the same redressal mechanism can also be used by an outsider. So supposing if you go to a mall and you believe that out there you've been harassed by somebody, then despite you not being an employee of that, I would say that departmental store or otherwise, you have the right to make a complaint against that employee with his organization. Again, it's kind of, most of the people are in a denial mode saying that it does not happen in our premises. It may not happen in your premises, but unless you don't enforce the law or you do not state the objective of the law to your employees that such a behavior is not tolerated within our organization and that we are a zero tolerant organization, and then in case if you are harassed within your organization, there is a redressal mechanism in place, complaints are not going to come in. And if supposing there is things happening, it is actually been, I would say, suppressed because women don't know that they have a right under the law. Again, this law being recently made, more and more people are now becoming aware of the law, and there have been recent instances which I will share with you where when the companies have not complied with the law, there have been severe consequences for the organization. Another myth is basically that you will comply as and when a complaint is received. The law is very clear that you have to comply. The entire emphasis of the law is actually prevention. That basically the government wants that once you sensitize your employees, once you create an anti-sexual harassment policy, and once you tell the people do's and don'ts, then they believe that sexual harassment as a behavior will reduce, and once it reduces, then the chances of harassment or a complaint coming in will be low. Having said that, if a complaint is actually registered, then the companies have to have an internal mechanism by which a redressal committee has to be in place, which will hear that thing. You cannot make a committee after a complaint comes in. It's because the woman has to know who to approach to even make a complaint, because the lady has to approach the committee and make a formal complaint to the committee. In case for some reason she is unable to make a complaint in writing, then the committee is obligated to help her make a complaint in writing and then go through the entire redressal process. Another fear commonly amongst business owners has been that it will result in false complaints. There is definitely a possibility of false complaints, but the law by itself actually provides remedy against false complaints also. So it's not only that in case a woman makes a false complaint, then the law provides action to be taken against the woman also. So once the law is implemented in letter and spirit, our belief has been that yes, false complaints may come in, but if it is addressed in the right way, then it will actually ensure by deterrent action that no further false complaints will come in. Again, that we are not aware of the law, that again boils down to not being aware of the law. We have not received any intimation from the government. Employees are not on our rolls. Again, out here, as I will take you forward with the definitions, the definition of an employee under the law is in the widest form. It could possibly be wider than in all the other labor laws for that matter also. And again, that I am not responsible in case if a woman is harassed within my premise. You are responsible to the extent of helping the woman make a complaint. You are not responsible for the action. However, in case you don't help the woman make a complaint, then there could be consequences against the organization as well. So, what are the obligations under the Act? In a nutshell, every organization has to have an anti-sexual harassment policy. They have to display their intent by putting up posters within their organization stating the penal consequences of sexual harassment. You actually have to form an internal committee at each location. So this internal committee is actually the committee which not only hears the complaint, helps the lady make the complaint, okay, but this is the committee which actually follows the principles of natural justice, hears both sides, and then gives a recommendation to the organization as to what action to be taken, like whether the complaint has been proved or not, and in case it is proved or not proved, what action should it be taken either against the aggrieved woman or against the respondent. You have to display the contact details of the internal committee within your organization, because people have to know who to contact in case there is a complaint. I think that the most important aspect of this entire law is actually sensitization and training of employees and ICC members. So basically what happens is that at some point of time, what a person says, he may not have any intention of harassing somebody, but it could be perceived as harassment by the lady. To give you an example, right, there are so many people who possibly come down to Bombay from tier 2, tier 3 cities, and they're working out here. Now, in some organizations, hugging amongst boys and girls may be a common norm, but this may not be something which the woman maybe from a tier 2, tier 3 city may be comfortable, or for that matter, even from a tier 1 city for that matter. Now, from a boy's perspective, if other people haven't objected to it, he may think this is acceptable, and he may go about hugging other women as well, and she may not perceive that, or she may not find that welcome. So that's where the sensitization and training program becomes very important, that it basically tells you that on what benchmarks should you consider your behavior. That one of the most important benchmarks is unwelcome to the woman. So you have to be in a position to perceive that what you are doing will not be unwelcome to the woman. And if you believe so, then you feel free to act the way you act. You have to understand what all comes within the purview of sexual harassment. You have to understand basically that there are certain time limits within which complaints have to be made. So it's not only about men, about women, it is about informing all of them as to what their rights and obligations are there under the law. Under the law, even a person against whom a sexual harassment complaint is made, he has rights. Both people have rights to confidentiality. I will take all of those things in greater detail as we go further along. Then basically, the company also has to provide adequate support to the ICC, because that's a committee. So whatever support the committee requires, the company is obligated to provide that support and ensure that the committee, which has to make a report at the end of every year, has to ensure that the committee makes that report every year and submits it to the organization. So the committee has to make a report to the organization as well as to the district officer, and then the company has to incorporate parts of this report and incorporate it in its own annual report. So either an annual report which you have to prepare because of Companies Act or any other act for that matter, or you have to file an annual report with the district officer, which is the government. Consequences of not complying with the law. So these consequences which we are talking about is actually a consequence with respect to the organization. This is actually a civil remedy for the lady, but if the company is not complying with the law, then this is a criminal offense from the employers, so which is basically the management of the organization. Here, under this law, you do not require vicarious liability. The management of the organization itself is responsible under the Criminal Act. So here it's not the organization which is responsible for the non-compliance of this law. It is the management of the organization which is responsible, and it is a criminal offense which is tried before a metropolitan magistrate. There is a fine of up to director, anybody. So it's basically trustee, director, and anybody responsible. So it's here you cannot define one director. Everybody comes in. Whoever is responsible, including the board of directors or the trustees, depending upon what is the constitution, everybody is responsible for it. The fine for the management, personally, again, there is no criminal provision for imprisonment under the sexual harassment law, but because the amendment of the IPC, okay, there have been instances where the management of the organization has been prosecuted or FIRs have been filed against them for abating the offense of sexual harassment, because you were required by law to do certain things within your organization, and since you did not do that, then by your omission you have actually abated the offense of sexual harassment, and therefore there have been instances where they have had to the FIRs have been filed against them, and then now they have to suffer prosecution on those accounts. As far as fine is concerned, under this law there is a fine of up to 1 lakh rupees, so 50,000 rupees at the first instance, and in a repeated instance double the fine, that's up to 1 lakh rupees. There is a provision of cancellation of your business license. So if basically if your organization is held liable and guilty of not compliance, then the court has the power of cancelling your business license or not renewing your operating license, as the case may be. A few instances where compliance has been there. So I think that the companies which have complied, there are very few companies who have actually complied in toto. Companies which have complied, most of the companies which have complied actually have an anti-sexual harassment policy, and they have an internal committee. Few companies have actually made only an internal committee across the country. So recently there was an example which was reported in the media regarding Sri Lankan Airlines, where they operate out of 7 cities in India, but they had one committee which was based in Colombo. The law requires that you have to have an internal committee at each location, so that the lady is in a position to complain to that committee, and not only complain to the committee, she is comfortable because the committee is actually comprising of people from your own organization. So you are actually complaining to somebody who you know, who you are comfortable with. So it kind of creates a, I would say, a conducive atmosphere to be able to even reach out to the committee. You have to form a committee at each location, and you also have to display their contact details so that women can make complaints locally. Training, I think so, which is very important. Most of the organizations have not done employee training. Apart from employee training, you also have to train the committee members, because they are the people who are actually eventually going to decide the entire complaint based on principles of natural justice. So in some sense, they are administrative judges, so they have to know what is principles of natural justice, what is the process, within how much time the complaint has to be provided, has to be forwarded to the respondent, what are the provisions of the law. So that is actually a very important part, and all these facts which I am actually bringing to your notice are obligations under the law which every employer has to fulfill. There have been some instances where the composition of the ICC is also not in consonance with law. So you actually require one of the committee members to be an external member. He could be either an advocate or a member from an NGO or an association which is supporting a cause of women. Now what has happened is, at times we've seen that there have been committee orders where committees have been formed where you've not nominated a person. You've said that this organization is part of the committee, which is not in consonance with law. You have to nominate an individual. So it's basically a committee of minimum 4 people. You cannot nominate an organization, or you cannot nominate by virtue of a designation. So there have been instances where they've said that the Vice President HR is the chairperson of the committee. The law requires that the presiding officer of the committee has to be a woman. Now in case, when you put a designation, it may so happen that in some organizations, the Vice President HR could be a man for that matter also. Or when you made the committee, he was a woman, the person was a woman, but you don't remember that the next time when somebody is changed that it has to be a woman only. So then at that point of time, your committee will not be in consonance with law, and you can be hauled up for that effect also. Again, so I will kind of take you quickly through the various definitions which I believe are important for you to understand. Aggrieved woman, you have the book, basically the BEAR Act, which is there as part of your folder. So in that, if you look at the definition of aggrieved woman talks about a woman of any age, whether employed or not. So when I said that it need not be necessary for the person who is making a complaint of sexual harassment to be an employee, the definition clearly provides that it can be a woman of any age. So you can be an adult, you can be a child, or you can be an older gentleman as well, lady as well, and you need not be employed. So even if you have come across in an organization as a customer, or as anybody for that matter out there, you're just passing by and you went to a place and you were passing by and the employees out there harassed you, under this law you have the right to make a complaint. Employee definition is as wide, in which we are talking about not only your employees, but employed through a contractor with or without your information, with or without remuneration, called by any name, whether apprentice or a trainee or any name for that matter. So therefore the employee definition in that way is extremely wide, So it takes within its ambit the same contractual contract labor obligation. So if any of your vendors employee has harassed some woman, then you are responsible to provide redressal. In employer, again, the employer definition is very wide. It talks about government organizations, it talks about whether you are an educational institute, a hospital, a service, or any service or manufacturing unit. It also talks about that it says, it specifically clarifies that basically for the purpose of this, at least for the private sector, that the board of directors, trustees will also be part of the definition of employer. Respondent is actually the person against whom the aggrieved woman alleges that he has harassed. Sexual harassment as a definition, it basically has 4 parts. Sorry, I'll just kind of take you through. So, sexual harassment includes any one or more of the following unwelcome act or behavior. So here what we're talking about, the emphasis is on unwelcome, and it is unwelcome to the woman. So it is not that if you did not intend, therefore it does not become unwelcome. It's basically if it is unwelcome to the woman, then whenever a complaint like this comes in, the committee will basically decide based on a normal woman, like what would a general woman in such a scenario believe that what happened was unwelcome or not, and based on that they will possibly try to decide as to who was right and wrong. So physical contact and advances obviously is kind of a very intuitive behavior which will amount to sexual harassment. On demand or request for sexual favor will also amount to sexual harassment. Making sexually colored remarks or showing pornography or any other unwelcome physical, verbal or non-verbal conduct of sexual nature. Again, you have to understand these are not defined words, so it will depend on the facts of each case. Therefore, it is very important for every individual to ensure that whenever they react in a certain form, be able to understand how it will be perceived by the other gender and then take it up from there. Sorry, one more thing which I forgot to mention about the respondent. Respondent need not be only a man. Respondent means it can be a man or a woman or the third gender. So under this law, it only says aggrieved woman. So the complaint under this law can only be made by an aggrieved woman, but the aggrieved woman can actually make a complaint against a man or a woman or a third gender, anybody. Companies can go beyond this law because this law does not say that you cannot go beyond this law. So there have been organizations who have provided gender neutral policies. But all the provisions of this act are for women only. Companies are free to actually go beyond this act as well. Again, workplace. Workplace again is very widely defined. So it's not only your office premises. It also includes any place you visit during the course or arising out of your employment. So if for some reason today, if people have come here and they have been deputed by their organization for attending this seminar, then even this seminar or this premises is your workplace for the purposes of this act. And if some allegations were to fly because of incidents which happened here, then this law will be applicable. Again, another specific provision has been made under for the workplace has been that in case there is a transportation provided by the organization for the employees to go to and fro, then even that transportation for the purposes of this act will be considered as workplace. So in the IT sector, BPOs, there is a prevalent, I would say, norm of providing transportation to the employees. And if for some reason, if an harassment were to happen there by that driver, then that has been specifically provided under the act. Then this is the internal complaints committee. So what I was mentioning is every organization which employs 10 or more people has to mandatorily constitute an internal complaints committee at each location. The internal complaints committee is as per section 4 of the act. It talks about it has to have minimum 4 members. The presiding officer has to be a woman employed at that workplace at a senior level. In case you do not have a woman employed at a senior level at that location, then you can co-opt a senior woman from any other location of that organization. In case you do not have a senior woman at any other organization, a location within that organization also, then you can nominate a senior, a woman employed as a senior level at any other group company within the location, within the group also. So the presiding officer has to be a woman only. It cannot be a man. 50% of the committee has to be women. There are 2 other employee members to be co-opted with, on this committee. Preferably they are saying that they have to be somebody committed to the cause of women or having legal knowledge, but that's not mandatory, it's preferable. And then you have to have 1 external member. The external member can be a member of an NGO or any association committed to the cause of women, or somebody who's familiar with the issues of sexual harassment. Example could be an advocate. So you have to form this committee, and then there has to be a formal order for this committee, and people should know who these committee members are all about. The state government has to appoint a district officer in each district. The district officer is responsible for the implementation of this law, and also that all the reporting, which is the annual report to be filed by the committee, as well as the annual report to be filed by the organization, has to be filed with the office of the district officer. Another important committee is the local complaints committee. So the district officer has to actually, I would say, nominate a local complaint committee in each district. Now the jurisdiction of this local complaints committee is basically for every organization which has less than 10 employees. As I mentioned, for internal complaints committee, it is mandatory for having more than 10 employees. If you have less than 10 employees also, you can form an internal complaint committee, but if you have 10 or more employees, it is mandatory by law to have an internal committee. In case you don't have 10 employees, then you have an option of not having an internal complaint committee. But what does a woman do in case you are harassed by an employee who belongs to an organization who has less than 10 employees? In such a scenario, the woman has to complain to the local complaints committee, which is formed by the government. So because smaller organizations do not have the infrastructure or the number of employees to form an internal complaint committee, for them the local complaints committee will hear these complaints. Another feature is that suppose so basically they want the wisdom of a committee. When you say district officer, you can always say that one person got biased. In the local complaint committee, the same logic applied. The presiding officer has to be women, it has to be majority women. So the logic has remained the same. It has to have an NGO member, the local person from the district who is a woman officer is an ex officio member of the committee, and all that is there. So they are trying to make it that it is a collective wisdom of a committee which has to hear the complaint, so that there is no allegation of bias against one person. If a complaint is made against the employer, then the internal committee should not hear the complaint. It has to go to the local complaint committee. So section 6 of the Act provides that in case where the complaint is against the employer, or in case where the organization has less than 10 employees, then the local complaint committee will hear the complaint. So this is, I would say, the reason behind that could be envisaged as so that women, when they make a complaint against the employer, they do not believe that because the employer was responsible for nominating the internal complaint committee, they will not get justice from the committee, and therefore the provisions have been made where a complaint against the employer can be made to the local complaint committee. Salient features of the law. There is a time limit provided for making a complaint by the woman. It is actually 3 months from the date of the incident, or in case of a series of incident, it is 3 months from the last date of 3 months from the last date of incident. In case for some reason you are unable to make a complaint within 3 months, then the committee has the option of extending that complaint time limit by another 3 months. But for that they have to state reasons in writing. So if you do not have a kind of a valid reason, then you have to make a complaint within 3 months itself. For some reason, supposing you met with an accident because of which you were unable to make a complaint and you were hospitalized, or some other genuine reason which you can articulate to the committee, then the committee, if it believes that you had a genuine reason, can record reasons in writing and allow you to and still hear the complaint despite you going beyond the 3 months, but within 6 months. Beyond 6 months, we believe that they do not have the right to hear the complaint. there is provisions of confidentiality. So section 16 of the Act clearly provides that that the committee and everybody who is involved in the entire redressal process, either during the inquiry or during the conciliation process, will not divulge any information which can lead to the identification of either the aggrieved woman or the respondent or the witnesses. And there are consequences of violating the confidentiality. This provides a time-bound redressal. So the entire inquiry has to be completed within 90 days. So the entire redressal process, again I'm orally articulating it, it is part of the law, is basically as soon as the complaint comes in, within 7 days. So when a lady makes a complaint, she has to, in the complaint, she has to file a complaint in 6 copies, and she has to mention the name and addresses of her witnesses and whatever supporting documents she has to prove her case in the complaint. This entire complaint copy, one copy of the complaint is forwarded to the respondent, who has to reply within 10 working days. After that, the committee will hear both the parties by following the principles of natural justice, in which case the lady will have to prove her case. It's not just that she said that it's kind of sacrosanct. She has to prove her case by leading evidence. Okay.
But if it is verbal, then?
So if it's verbal, you will state that on oath before the committee. The other person has the right to cross-examine you, and based on whatever comes out during that meeting, the committee will decide. So what we are saying is, it's just that it's not that your allegation is taken without proving it. You will have to prove it. So if you don't have any documentary evidence, you have to prove an oral thing. You will have to state before them what happened, and the other party has the right to cross-examine you. Either parties cannot get a legal practitioner there. So this is basically where you have to, both parties have to lead their own case. It has to be done. So 7 days, within 7 days the complaint has to be forwarded to the respondent. The respondent has to respond within 10 working days. The committee will promptly hear both sides of the story, and then it comes out with its finding whether you were right and wrong. If both parties are employees, then you have to give a finding report to both parties, and they have a right to make representation against the finding. So in case you believe that there is some part of the evidence which they have ignored by oversight, then you can actually bring it to their knowledge that if you had considered this part, then your finding would have been different. The committee will consider the representation and make a finding and a recommendation. So if the committee comes to the conclusion that the complaint is proved, then they will recommend appropriate action, right from termination to doing community service, to reprimand, to demotion, to monetary compensation. There is a provision of monetary compensation as well. So in case a complaint is proved, then the committee will decide as to what is the monetary compensation payable by the person to the woman, and due consideration will be given to the status or the I would say of the respondent. Here it is not about the aggrieved woman, it is depending upon the status of the respondent, the career loss opportunity of the woman, the mental trauma and the physical trauma which she went through, and the committee can actually decide to grant this compensation in installments as well. If the committee comes to the conclusion that the complaint is not proved, that they don't come to the conclusion that it was false, but they are unable to come to a conclusion whether the woman is right or the man is right for inadequacy of evidence, then they will just close the case without recommending any action to be taken against either parties. However, on the other side, in case the committee comes to the conclusion that the lady has made a false complaint, or the evidence which was led was false, like supposing you allege that he wrote a letter to me, and for some reason it is actually held that that letter was not written by the gentleman itself or any other person, then in that case, if the committee comes to the conclusion it was false evidence, then the committee has the power to recommend similar action to be taken against the witness or the aggrieved woman. The only thing what we believe is that there is no provision under this law for monetary compensation to the respondent. So monetary compensation is only for the aggrieved woman in case the complaint is held to be true, but not the other way. Though since this law is in addition to every other law, under general law of torts or under criminal law, you may have an option of making a monetary claim. But under this law, it's only the woman can make a monetary compensation. Principles of natural justice. It's not that whatever.
The other person against whom the malicious complaint has been made, and now proceeding under the IPC for.
So there is perjury provisions under IPC also, where the courts have the power of giving monetary compensation, though that. Yeah, perjury. So there is criminal, because even this is like a tribunal. So a false statement before a body like this also is a criminal offence under IPC. So we believe that you have those remedies already there. Principles of natural justice. Okay, it's not one word against the other. Whatever the woman says is not sacrosanct truth. Though the committee should be empathetic towards her, that she's made a complaint, so they should listen to her with an open mind. A burden of proof. This being a civil law, the lady or the gentleman has to prove probability and not beyond reasonable doubt. There is punishment for false and malicious complaint. Anybody who's not happy or satisfied with the recommendation of the committee has a right to make a complaint before the industrial tribunal. Now, if you are an organization to which there are service rules, then the service rules will apply. So in case there are service rules, so for teachers it could be the school tribunal, for government officials it could be the CAT, Central Appellate Tribunal. In case you don't have service rules, or there are not other appellate remedies already provided, then they are saying that in that absence, it's the industrial tribunal which will hear the appeal. The appeal has to be made within 90 days from the date of recommendation. There is a provision, and another one important feature is there is a provision for conciliation. So but this conciliation option is only available to the woman. So after making a complaint, the woman doesn't want to take it through the entire inquiry. Okay, but she said that okay, I am willing to have an out-of-court settlement with the respondent. Then the committee can actually, at the request of the aggrieved woman, try to have a conciliation between the parties. Again, another important thing I want to mention is that monetary compensation cannot be a basis of conciliation. So this is to ensure that in case of false complaint, there cannot be any allegation of extortion or something. Okay, so if supposing some lady felt offended by some statement, and for her she makes a complaint, but she's happy with an apology, that she believes that if the person apologizes, I am willing to withdraw my complaint. Then here, when she said that okay, I want to reconcile, if both parties are agreeable to whatever conciliation mechanism they agree to, the committee will record the conciliation order, and then it will close the matter. So in this case, what happens, it's not that it's off the books. It's basically that you have recorded a complaint and then you want conciliation. There is an attempt to conciliate, and if the conciliation happens, then it's recorded so that it's documented. Tomorrow, either party cannot turn around and say that I wanted to make a complaint but I was forced not to complain, or vice versa, as there have been instances. There is also a provision for interim relief. Then if you make a complaint and if you have not opted for conciliation, then during the inquiry process, the woman has an option of interim relief. She can request for her being transferred to another location, or the respondent to be transferred to another location, or to be given leave for up to 3 months, because the complaint has to be inquired within 3 months. So she can ask for leave for up to 3 months, and this leave is paid leave in addition to every other leave which you have. In case of an educational institute, you can ask for that, basically that in case you made a complaint against a professor or somebody, that he should not be supervising my activity. And so in the case of an organization, that person should not be reporting on my performance. Again, unwelcome, I've mentioned. Unwelcome is to the woman. It is not the intent but the impact which matters, and it will be judged from a common man's perspective. Quid pro quo is where basically you harass somebody asking for a favor or something, then that would amount to quid pro quo. And hostile work environment would be possibly that in your organization as a management, you hear that there are rumors being circulated about some particular woman, and despite the management being aware of it, is not taking any action, then this can be perceived as hostile work environment. So organizations have to ensure that within their organization, these kind of actions are not taken, and once brought to their notice, they have to make sure that they nail it in the bud, so that tomorrow people do not have any recourse against the organization. As I mentioned to you, disclosure requirements in the annual report. So from this August audience perspective, this would be one of the important features. So section 22 of the Act provides that the employer shall include in his report the number of cases filed, if any, and their disposal under this Act in the annual report of his organization. And where no such report is required to be prepared, intimate such cases to the district officer. So therefore, for organizations like companies for sure, and trusts and societies, because they have to file their annual reports either with the charity commissioner or with the registrar of societies, they require an annual report. So they will have to incorporate this information within their annual report. And for all other organizations who don't have to are required to make an annual report under the respective laws, they have to file a report with the government, with the district officer. And this is so because the provision of this Act is in addition to and not in derogation of any other provisions of any other law for the time being. So if you have any other remedy under any other Act, you still have this remedy either as an organization, as a respondent, or the aggrieved woman. These remedies are in addition to every other remedy which you have. And we've given you a summary of how, if a company secretary or a chartered accountant or any other person wants to disclose, what kind of disclosure will suffice within the annual report. Our thoughts on the law. Again, so this law is a complete code by itself. It kind of provides for every eventuality. It puts the onus on the workplace owner to help the aggrieved woman seek redressal. Any law can be misused, and basically the solution is to enforce the law properly through the internal complaint committee or the local complaint committee by creating deterrents for misuse. Law itself provides for adequate deterrent punishment for the respondent as well as for the aggrieved woman in case of a false complaint. It also provides a deterrent against the organization for not complying with the law. So the law per se provides adequate deterrent to make sure about the compliance of the law. Aggrieved woman has additional remedies in addition to the said law, perjury, compensation under law of torts. Currently this law is only for women, but government at a later stage can make it gender neutral. So there have been questions as to why it is only for women, why it is not gender neutral, and why does government have to have a law like this. So even under Article 15 of the Constitution of India, governments have the power to make laws specifically for the benefit of women and children. And to say that why did India have a law like this, or what was the requirement for the government of India to make a law like this in December 2013, all our neighboring countries have law like this. Pakistan got a law in 2010. Nepal got a law on 18 February 2015, which is about a month back. Sri Lanka has a law, though on the criminal side only. So therefore, all our neighbors also already have this law. And what we believe is that if this law is implemented properly, then harassment can come down dramatically, because this ensures that the woman is not left high and dry at every location. So what it basically just obligates the organization is to assist the woman. You are not responsible for the action of the individual. You are responsible to ensure that you try to prevent it, and despite that, if it happens, then it's basically a bilateral thing between the two parties. As long as you have sensitized them, as long as whenever anything has been brought to your notice, you have taken care of it, the organization as well as the management is safe in that regards. So just to kind of give you a context, so if we were to look at the Tarun Tejpal case out there, if you would read on the newspapers, you would hear that the management of the organization mentioned that the lady wanted an apology, and thereafter when the apology was obtained from Mr. Tejpal, that she said that she was not happy, but that is what she wanted, and therefore they did not tell her to make a complaint. Now if this law was implemented by then, and if the lady would have been directed to make a complaint with the committee, she would have made a complaint with the committee. And if thereafter she had requested for conciliation, it would have been documented that she had requested for conciliation. If conciliation would have happened, then it would have been recorded, and that would have brought a matter to the close. Okay, and therefore these kind of allegations would not have flown against each other, because today what is happening is one word against another. The organization claims that this is what the woman wanted, and we don't know the truth. Again, whatever I'm saying is based on what has been reported in the media. So we just to highlight that in case the law is implemented properly, letter and spirit, it can ensure that the organization and its management is kind of taken care, so that tomorrow allegations don't fly against each other. Again, another example of recent Mr. Pachori's case. Here, initially the lady mentioned that she has no faith of deposing before the internal complaint committee. She has actually made a civil complaint as well as a criminal complaint. There is no law which bars you from not making a criminal complaint. Our personal view is that women, if given an option, prefer a civil complaint. But yes, if the action alleged is very severe, they will address both the remedies together. So in this case, since Mr. Pachori is the employer, our view is that this complaint actually should be heard by the local complaint committee and not by the internal complaint committee. And if you read from the press report, initially she had stated her apprehension of going before the internal complaint committee, because she said that this committee is reporting to the Director General, who is Mr. Pachori, and therefore she believes that she may not get adequate justice from them. She is deposing before the internal complaint committee, but our belief is that she has not been advised adequately, that in her case she can actually go to the local complaint committee.
No,
She can. The only thing is she has to know of the remedy. So somebody in her team or whoever is advising her has to advise her that she has an option before the local complaint committee, which is section 6(1) of the Act. So about a year back, there has been an instance where one of the leading private insurance companies, again there was an allegation that some sexual harassment may have happened within that organization, and she did not get adequate redressal within the organization, because of which she approached the criminal court, and the magistrate actually directed the registration of the FIR against the entire board of the insurance company. And because of which the management, the entire board of directors had to approach the High Court for anticipatory bail, which is, as per our last understanding, which is still pending. So they've got interim relief, but it's still pending. So this is what I mentioned to you, that under this law, under the Sexual Harassment Prevention, Prohibition and Redressal Act, there is no provision for imprisonment, but it is a criminal offence tried before a magistrate. And this is in addition to every other law in place. So therefore, there is a risk where, in case if you have not complied with this law, you can be hauled up for abatement. Having complied with the law, you will be pretty safe on that count. Again, this is again a recent example. Madras High Court in September 2014 actually fined one Chennai-based company 1,68 lakh rupees as compensation for not having an internal complaints committee. In this scenario, the lady was a senior woman within the organization, and she was harassed. She wanted to make a complaint, but there was no internal committee within the organization, because of which she had to make criminal complaints, civil complaints, and the matter reached the Supreme Court. Supreme Court, with the consent of both parties, appointed an arbitrator, and that matter reached the Madras High Court, and the High Court held that basically, if the company had an internal complaint committee, two things would have happened. She would have got prompt redressal. She would have made a complaint. The committee would have heard the matter, and they would have recommended accordingly. If the committee would have found that the person, the gentleman, was wrong, or he had harassed her, then he would have been thrown out from services. In case it would have been the other way, that in case the committee would have come to the conclusion that the lady had made a false complaint, then she would have been forced to resign from their organization. Because you did not have the committee in place, she had to run door to door. There was career and opportunity loss. And in that regards, so at first it held that yes, there has been a liability on the organization under the general law of torts, that the company is responsible to provide a safe working environment. And then the issue was how much compensation should be given to the lady. And there it awarded 1,68 lakh rupees recently.
Compensation is paid by the company.
Compensation is paid by the company.
No, nothing against the person.
No, because what happened was the complaint was not heard. So here what we're trying to say is that basically that if you comply with the law, then the company is protected. So at the end of the day, not only do you protect yourself, but you also provide a safe working environment for women. So you are complying with the law, providing a safe working environment, and also safeguarding you against any penal consequences, which can be criminal as well as civil for that matter. So basically that's it. I won't take you with that. Sorry, I can take questions now.
Any questions?
According to what you say, we should see all these sort of posters in all the malls, wheels, everywhere. But we are not saying, seeing so many here and there. We are saying, but who is the committee and all? We are not seeing in any of these.
No, I think so. You're not seeing it because they've not complied with it. So if you look at my statistics, and I'm telling you, when government is saying that 90% of private sector has not complied with it, when government is saying 90%, it can't be lower than 90%. It has to be higher than 90% only. And our statistics show that at least at Nariman Point it was 97. It is a random statistics. I'm not saying that it was for 450 organizations that which we did. But if government is saying 90%, I'm saying let's look at 90% for that matter. So I am saying that there people have not complied, and when we say they've not complied, it's not because they don't want to comply. It's because they're not aware that such a law exists. So today when we are saying that the biggest challenge is awareness. Once you are aware, then you may choose to comply and not comply. But if you're not aware only, it's impossible for you to comply. So therefore the first thing is awareness. And now being year-ending approaching, at least companies and societies and trusts have to do disclosure in their annual report. Or for that matter, then they will have either they will not disclose or they may make false disclosures for that matter, which may not be the ideal way of going about doing things. So therefore it's high time that you start complying with the law.
Yes, anybody?
Sir, internal control committee. So there is a third C, one member from the non-government organization or association committed
To the cause of women.
woman and the person or a person
Familiar with the issues of sexual harassment.
The person who is familiar can be an employee of the organization also?
No, so out there the intention is that the last person has to be an external member. So out there, so basically they're talking about it's minimum 4 people, you can have more. 50% have to be women, chairperson has to be a woman employee, the other 2 have to be women employee. The 4th person, their entire idea is to basically have an external member. So that person should not be an employee. He can't be an employee. He has to be. So you can have an advocate for that matter because he'll be familiar with the issues of sexual harassment, or an NGO member, or a legal consultant. Yeah, or a legal consultant. See, basically, it's as long as you believe and he has understanding of issues relating to sexual harassment, I think so. You are satisfied. So that is again subjective to your own understanding. Our thing is, as long as you are qualified as an advocate, you go through the barrack, you understand what the law is all about.
Suppose complaint is made against the internal committee member itself.
So if the complaint is made against the internal committee member itself, again there is certain there is a provision as basically eligibility of being an internal committee member, where it says that anything which you do should not be prejudicial to public interest. So if a complaint is made against the committee member itself, then that person will not be part of the hearing. So the quorum for every hearing is actually 3 people, including the presiding officer. So if unfortunately if the complaint is against the presiding officer itself, then you are in a problem. Maybe then you may have to reconstitute the committee for the purposes of that complaint. But as long as it is for somebody who is not a presiding officer, then our belief is that all that person is doing for the purposes of that complaint, and that person should not participate in that proceeding, because there you are the complainant. And once a complaint is made against you, so the other eligibility under the law also strikes in that it says that basically no committee member should have any disciplinary proceeding pending against them or any criminal complaint pending against them. So once a complaint is made, there is an view which can be taken that till such point of time you should actually not be part of the committee itself. So once the complaint is taken care, then obviously you can, if you kind of absolved of the allegation, then you can actually come back on the committee.
If there is a owner of one shop, and then if some lady comes to him and he is harassed, then
So anyway, that goes to the LCC because it's an owner. So therefore, as an employer is there, what we're saying is, so therefore here they've not made a distinction between number of employees. So they're saying that so possibly every kirana shop for that matter has to comply with this law. Applicability from a law perspective is actually anybody and everybody. Whether it is humanly possible or not, I'm saying we are not on the compliance world. We cannot comment on the adequacy or the inadequacy of the law. We have to comply with the law as it stands.
So even the time limit which you mentioned, that will also apply to the local.
Yeah. So it's basically the local committee and internal committee. The only difference being that for a smaller organization or against the employer, for those relevant reasons, that for a smaller organization it is a like to have a committee and to provide infrastructure to that. It's an obligation. So they're saying that for a smaller organization, the only leeway which they've done from a smaller organization is not have an internal complaint committee and not have all the paraphernalia attached to the internal complaint committee of training an internal complaint committee, of supporting an internal complaint committee. The similar support you have to provide to the local complaint committee. So if supposing a complaint with regards to your employee goes to a local complaint committee, then what happens is if supposing out there a notice or a summon has to be put on the man, then in that case all that support has to be provided by the organization only. So basically the only difference being that instead of a local complaint committee we are going to a local, instead of an ICC we are going to an LCC. Otherwise obligations from an organization perspective all remains the same.
In case of a sexual harassment complaint in a mall, is a person who is not an employee of that mall.
The only thing is the management of the mall should, in case the woman comes and approaches maybe a mall manager or somebody, says that listen, I've been harassed. You cannot say that this is it's a private problem, I don't care. I think so. The only thing which the law provides is basically that as an owner or as a manager of the organization, you have to help the woman make a complaint. Now, it could be a civil complaint or it could be a criminal complaint. If she wants assistance from you, you should provide that.
It will not be tried under this. Can it be tried under this?
No, that's the same thing. The obligation are under this law. So supposing tomorrow you say I went to him and I wanted to make a complaint and for some reason he didn't help me, then maybe that will amount to non-compliance for which you can be held up. So the thing out here is it's no longer a moral obligation, it's a legal obligation today. That if somebody is harassed within your organization, okay, or within your organization premises, sorry, that you should help that lady. So I think that's the only thing, I think that's the only difference. That earlier, maybe if within a mall you said this is a public premise, I can't be held responsible for helping every woman who gets harassed out here, though I don't think so most people do that. But yes, if somebody were to say that, I think so they no longer can say that.
But sir, usually harassment is outside the office premises only.
Yeah, so I am saying out here office premises, we are saying premises. So when you are saying office, what we are saying is, so let's look at like this, that supposing a woman has gone to watch a movie on her own and somebody harasses her who was sitting next to her at that point of time, then very frankly that person is not your employee. Okay, but he has been harassed within the mall, within the theatre. The theatre is owned by somebody. If you go to the theatre manager who's on duty there and request him that help me, this person harassed me, so you will say that listen, come with me and tell him that he can't do anything, and you say no, this is something which you have to do between yourself, we don't care. I think so that's the only thing you cannot say any longer. Having said that, it's something where the company cannot provide that civil remedy of a internal complaint committee or a local complaint committee. That's the thing which cannot be provided. But you cannot tell her that listen, I'm not going to help you make a complaint. So supposing if it was I would say a private show with one company had actually booked the entire theatre, okay, and there the employee out there came in because of some work, because like so you are actually, your guests are coming and you are helping your guests with food and stuff like that. So at that point of time, for the person against whom an allegation is made, it's a workplace because he is there for work. So I'm saying on a scenario, there could be a scenario where despite being in a theatre, it could be a workplace for the guy because they had organized a special show for somebody. So what we are saying is, what we are saying is the law provides that the woman should be assisted in whatever law possible is possible, nothing more, nothing less.
Can there be a common policy amongst subsidiaries and holding company, situated in the same premises?
The policy has to be company specific because the reporting is company specific. You can have the same policy and adopt it in every organization, but to say like a common Tata code of conduct may not work here. You may have a Tata code of conduct, but you still have to have a sexual harassment policy of each organization.
In the theatre example, you can only assess the criminal complaint because there can't be any local level complaint.
No, but so you can, so supposing you do not know who that person was, so helping him know who that person was from which organization and then helping that lady make a complaint there. When we say help, it can be civil or criminal both. All we think is like to get contact of that organization maybe. I'm saying help in what form will depend upon what help she wants. What we're talking about is providing a redressal forum.
If footage is asked for, they can give.
Footage is another thing.
Correct. So footage, so the committee actually has a power of the court. These committees have been given similar powers of CPC where actually they can actually give a notice to the theatre and say send me the evidence. So for specifically for 2-3 aspects, one is discovery of documents and evidence and giving oath and summons to parties. The internal committee and the local committee has been given powers of the court as CPC for that matter.
Last question. Any few instances which have come across you can share?
No, so instances have to be confidential, so they cannot be referred.
Example.
So examples, I give you 2-3. I think so to give you a flavor as to what can come through. Basically, only those places where redressals haven't come in, you will come in public domain. If you start looking at annual reports of organizations, and a few of the companies have actually done disclosures about this law in the last year's report itself, for the 3-month period itself. You will see that there have been instances of complaints having been stated in the annual report that yes, we got complaints and we've disposed them of. So complaints are there. Again, it's not only appropriate, it won't be appropriate to even share details, and theoretically we cannot share details as per the law itself. So factually you can't get into it, but I think so to hear about sexual harassment complaints coming, I don't think so there is a single day where you don't pick up the newspaper and you don't have one instance of somebody alleging something.
What made you to go for this particular cause, as an NGO, as an activist, or
as far as our organization Complykaro is there, again there is a need. So if you were to ask me from a commercial perspective, what we're saying is there is a need of the hour. And when we started initially, our thing was that there is no awareness at all. So initially we are talking about awareness, so that could be
Training itself is an opportunity.
correct. So we are not only doing training in that matter, but as far as our service is concerned, we are saying we want to help you because only training is not going to help you. Constitution of the committee. So here what we look at like this is that today you have to go to multiple people. So for a policy you may have to go to an advocate, for training you may have to go to somebody else, for an NGO member you may have to go to an NGO. Smaller organizations don't have that kind of bandwidth. They are also not able to spend that kind of money because bigger organizations have bandwidth and money, and they understand the implications also, they are aware also. So on all these counts which we believe is that most of the organizations are not aware. So our philosophy is, can we help these organizations first, make them aware of this law, and then help them comply with it. So again, this is the beginning. The need out here possibly may be the highest because of the ignorance of the law. But having said that, our idea is going forward, we want to basically help companies comply with a lot of other laws as well.
Okay. Now I, on the behalf of CCGRT, extend a very hearty vote of thanks to Mr. Vishal Kedia for accepting our invitation to come here and sharing the information related to the sexual harassment of women at workplace and disclosure in the annual report. Thank you very much.
So you have to declare that session is over.
Now the session is over.